It's a pleasure to be up here at the front of the room with such a distinguished panel, and I think we should move immediately to a discussion as quickly as we can, but it behooves me to say something about each of our panelists, certainly. On my immediate left is Assistant Commissioner Ian Atkins, Commanding Officer of the RCMP in Nova Scotia. Commissioner Atkins has 34 years of experience in policing. He's been posted to Nova Scotia, Prince Edward Island, and in Ontario. He has an undergraduate degree in sociology, which has a certain kinship for me, I must say, having come from a similar background. He has a degree in law from the University of Western Ontario, University of Ottawa, common law section, we determined, and spent 8 years in doing internal discipline in the RCMP in Ottawa, and indicates that that was his primary time as a practitioner of administrative law. But at any rate, it's a pleasure to have you with us.
Thank you, sir.
And perhaps I'll move to the left, and this will be the order of speaking for the evening. Next to Commissioner Atkins is Duncan Beveridge, who would be familiar to many of you in this room. Duncan was admitted to the Nova Scotia Bar in 1979. He worked for the Attorney General of the province of Nova Scotia in the area of criminal law until 1984. He then moved into private practice, where he concentrates in the area of criminal defense. He is a former president of the Nova Scotia Criminal Lawyers Association and of the Canadian Bar Association Criminal Law Section for Nova Scotia. So welcome, Duncan.
Thank you very much, Bruce.
And on the far left is somebody who would have been familiar to hockey enthusiasts in Halifax in the period of the...
Don't say how many years ago, Bruce.
No, I won't. It's, you all remember the Voyageurs, don't you? And Justice Watt's performance, or the then-to-be Justice Watt's performance on that team. But David Watt is a justice of the Superior Court of Justice of Ontario. He really leads the Toronto Homicide and Long Trial team. But those of us who are involved in practicing criminal law or teaching criminal law will be familiar with many of Justice Watt's publications, law review articles, editor of Tremere's Annotated Criminal Code, Watt's Manual on Criminal Evidence, and so we have a scholar, practitioner, judge on the far left, but somebody who still is seen on local hockey rinks from time to time here, where he is presently on sabbatical from the courts in Ontario and is a welcome addition to the teaching team in the area of criminal law at the law school this year. So we're pleased to have you here, David.
Thank you, Bruce.
So let's move ahead. Trust in Justice is the name of the series, and as you know, we're going to be, after Rosalie Abella's wonderful start to the series, we're looking at criminal justice issues tonight. There will be discussion of civil justice issues and family issues. It seems to me, though, that the organizers have set some common questions for us to consider, and they're four in number. One is, should the public trust the criminal justice system? Or to put it another way, are there compelling reasons not to? Thirdly, and I suppose this is a kind of empirical question which we'll speculate about to some degree, is the public satisfied in the way in which offenders are treated? And I guess that would go for others in the criminal justice system, involved in the system, victims, witnesses, and so on. And finally, is there a sense that the criminal justice system adequately protects the public? These are large questions, but everybody here has their own perspective. I guess that I'm entitled to say some things about my perspective, and I guess one of them is that I'm concerned that public perception, and that is what some of these questions are oriented to, is largely media-driven. And it seems to me that the media concentrates on possible scandals at all times, and these scandals can be relate to the failure or the slowness, perhaps, to catch and deal with horrendous criminals, right? And we all see the media splashed with names like Olson or Bernardo or now Picton, right? But then there's the other side, sort of the manifest injustice of wrongful convictions. And we think of names like Truscott and Millard and Parsons, or in this province, Marshall. We see the media pushing fear of neighborhood crime, whether swarmings or drug-related crime or prostitution. And we also see a phenomenon, I think, in the media, which is what a Dutch criminologist calls victimalization, and that is that victims' interests are immediately valued and perhaps emphasized by the fact that it's very often easy to find a victim who will go before the cameras expressing outrage. It's difficult to find people who are willing, from the criminal justice side, to present perhaps a balanced picture. So I think that what's interesting is that much of the public perception of criminal justice matters does not correspond to the understandings that many involved in the system itself have. So that's a concern to me. I think that some of the non-mediatized realities of criminal justice are interesting and have changed a great deal over the time that many of us have been involved in the criminal justice system. But I think that from my experience trying to examine criminal justice in other places around the world, the degree to which the rule of law is indeed entrenched in the Canadian criminal justice system is, from a global perspective, not unique, but very special. The extent to which there is competence from most of the people involved in the justice system is not unique, but certainly very special. And the absence of corruption in general is not unique, but very special. So I think that these things are significant. I think that the advent of the Charter, which is, 25 years old or thereabouts, has been significant in providing a firm exclusionary rule of evidence, which has changed the nature of our criminal justice system, I think, for the better. One of the things which has been important, it seems to me, in Canadian criminal justice has been the role of commissions of inquiry. We've seen a lot of change as a result of commissions of inquiry across the country in relation to the many of those wrongful convictions which I mentioned, and certainly the Marshall inquiry had a significant impact here. And it seems to me that this complex system, the criminal justice system, has in the last 25 years or so had the various discretionary capacities of the actors in the system limited and structured, so that we see police governed by protocols. We see prosecution services governed by guidelines which are now publicly available, which they weren't 25 years ago. You know, you made the decisions, you couldn't challenge them, you didn't know why. Sentencing is now more structured than it once was, it seems to me, and corrections as well. All of these sets of structured rules lead to systems of accountability, and those seem to me to be important, but they seem to me to be things which are invisible to the general public. Finally, and I'm I'll tell you what the timing ground war rules are, and I don't think I've been abusing them. It seems to me that we have in Nova Scotia, unbeknownst to many in Canada and in other places in the world, an interesting set of experiments which have gone on. And I think in some measure it's because the jurisdiction is small enough that one can get a critical mass of people together and make some change, very often under pressure. But you can get change. And we're interestingly different than some provinces. I think it's interesting, for example, that the RCMP is the provincial police force here. That creates a kind of distance from politics, which I think is probably healthy. We have an independent public prosecution service, statutorily independent, which kind of arose out of the Marshall Inquiry. That's now being imitated in the province of Quebec and is being adopted federally, and was pioneered here in this province in the Canadian context. We have a youth restorative justice program which is more developed than any in the world with the possible exception of New Zealand, and I think it has important capacity in relation to a certain type of offense and in relation to various communities. And we now have a formal justice, trial system, and more than that, a criminal justice system where victims' interests are recognized through police protocols and prosecution protocols and victim impact statements and faint hope hearings and parole hearings in ways which were certainly not the case 25 years ago. So while there are lots of human errors and lots of things which can be improved, it seems to me that we've got an interesting justice system when seen from a global perspective. And when we're trying to improve things, I think it's really important that we not throw the baby out with the bathwater, and we appreciate building on success as an approach to criminal justice issues. And I think that ought to have something to do with public trust. But it's a complicated story, isn't it, to present in a 30-second news clip. That's the problem. Anyway. The ground rules are essentially that we're going to take 5 to 7 minutes for each of the panelists to express their initial views. We're going to ask the panelists to perhaps respond to the others in 10 minutes or so, and then have 35 or 40 minutes of questions from the floor, a kind of, I hope, interactive debate. And then it says there's 10 minutes for the moderator's summary and closing, but I think I've probably spoken enough, and that could be cut down substantially. So with that, Ian.
Thank you very much, Bruce. I should have no difficulty keeping under 7 minutes. I had about 10 pages scratched out, and after your introduction, I'm starting on page 8. The Canadians are fortunate to have the criminal justice system that we have, founded as it is on the rule of law. And it's a legal environment where freedoms are enjoyed, not because there are no constraints, but because the constraints are enforced in accordance with prescribed and authorized laws. And one of the measures of the success of a criminal justice system is how well it protects those who are most unable to protect themselves, or those who are marginalized by the powers of the state. And I think, measured by that standard, the Canadian justice system is successful. But not everybody is content. And from a police perspective, we get that discontent on a daily basis from the victims and from the complainants that we get in colorful language and without order. And it's just a barrage. So they're gauged by that public opinion. Not everyone is content with the system that we have. But I detect it's not a crisis of fundamental principles, of lack of fairness or lack of due process. But there appears to be a crisis of faith, trust, and confidence in the system. And it appears that the criminal justice system that we enjoy doesn't sufficiently hold offenders accountable. And from my perspective, from the police perspective, it's not accountable because we either can't investigate, because we don't arrest, because we don't charge, because we don't convict, or because sentences are inadequate. Any one of the above. One of the main functions of the criminal justice system, as everyone is aware, is to reflect and advance the fundamental norms, social norms and values, and to validate standards of behavior. And when a criminal justice system doesn't perceive to do that, then obviously the public loses faith in that system and probably highlights the essential need that the public does have trust. I'm going to advance three theories from my perspective. One of them has been well handled by Bruce in terms of the perception versus the realities of the system, the public perception of the system. The second point I want to cover is the cynicism about the system because of some sentencing practices. The third focus, which is probably I'll spend a fair bit of time on, is some fairly recent judicial decisions and legislative changes that have increased the complexities of the criminal investigations that have eroded law enforcement's ability to investigate crime and therefore diminished the public's confidence in their expectations. As Bruce said, the public perceptions are formed largely by the media, whether print media or by television, and if by television, by news broadcasts or by crime shows. And by that I mean the CSI Factor, the 30-minute crime solutions, the instantaneous forensics, which raises public's expectations that that's what reality is. It's not. Very few journalists read case law. Very few of the public read case law. And what the media does report are the outrageous, the bizarre. The more bizarre, the more outrageous, the more crime sells. We all know that bridges that are holding, planes that fly, and rivers that flow don't make news. Bridges that collapse, planes that crash, and floods make news. And that's what the media tend to report on, and that is probably what the public perceives as the norm. They don't report on the hundreds or even the hundreds of thousands of cases a year that routinely process through the courts. They focus on where justice has failed or where there's been an outrageous outcome. An accurate judgment of the criminal justice system can't be determined by the outcome of a case and the media report by the case. The public make their own determinations based upon their perception of the guilt or innocence of an accused based on the facts they believe that they know. Whereas the judge decides based upon the facts that are filtered through the rules of evidence, the screens of prejudice and reliability. So the actual outcomes might not accord with the public's expectations. And the public opinion must be an informed opinion, not one that's formed by anger, emotion, or misperceived facts. But we can't blame the media entirely. I think the practitioners in the criminal justice system have an obligation to explain the process, to explain the criminal justice system in a way that the public can understand. Without those proper explanations, the criminal justice system is beyond the reach of most Canadians. So they rely on the sensational cases to form their opinions. The second focus is on the realities of sentencing. You'd think from a police officer I would be saying that sentences are too lenient, and perhaps that's the public's perception. I don't believe they are too lenient, but I believe there is a degree of dishonesty in the understanding of sentencing from the public. I'll give you the example. Very few of the public would realize or would probably consider a 12-year sentence for a significant crime a fair punishment. However, they're probably not aware, or they don't well understand, that day parole is the accused or the offender is eligible for day parole after serving a sixth. So that if they see them on the street in 2 years, they think their sense of denunciation has been seriously discounted. Or they've got parole after a third of the sentence, or statutory release after 2/3. The objectives set out in the Criminal Code 718 and 718.2, 17.2, of denunciation, deterrence, separation, rehabilitation, and reparation, and promotion of the sense of responsibility. If those are the principles, we have to question whether, in fact, those denunciations and separation from the community are accomplished in sentences that are discounted 6-fold or even 3-fold. And discounted sentences have actually become institutionalized in that dead time custody or remand custody is credited sometimes 2 for 1, 3 for 1. And because the accused has not been convicted of any offense, there's no obligation to undertake any programs. So where's the sense of rehabilitation? Most offenders are plagued with disadvantaged backgrounds, substance abuse, mental illness, poverty, learning disabilities, poor education. What does any of the sentencing principles have that will ameliorate any of those realities? Perhaps parole does more to assist the management of the prisons than it does in advancing the behavioral changes of the prisoners. Perhaps it's time to get honest with sentencing. If a 12-year sentence is going to consistently net out 3 to 4 years in actual custody, why not sentence the accused to 3 to 4 years in actual custody with a small portion reserved for good behavior, earned behavior? That way there will be a nexus between the sentence that's imposed and the sentence that's served, and it may assist in rehabilitating some of the trust in the system. My final point, I'd like to touch upon some judicial decisions recently, well, since the Charter, that have had a significant impact on police capacity to investigate and the public's perception of maintenance of public safety and public order. The first case is Hunter and Southam in 1984, which declared warrantless searches unconstitutional. And that was the start of the march for time required to prepare affidavits and seek authorizations which extended investigative time. Terrans was the next one that in 1985 were defined detention for purposes of Section 10, the right to counsel in impaired driving cases. And then there was a whole myriad of cases that followed Terrans, with the result that a 2-hour investigation pre-charter is now a 6-hour investigation for the same offense, which detracts from the availability of the police to patrol streets and be visible in terms of protecting communities. Garofoli in 1990 required full, frank, and fair disclosure for Part 6 intercept warrants. As a result of that decision, it's now not unusual for a judge to have to read through 500 to 1,000 pages of an affidavit. These often require a full-time affiant assigned to a file who does nothing but write affidavits, so that by the time one expires, the other one's ready to go. And it's not unusual that the affiant can spend 6 weeks on the stand testifying to minute detail, again detracting from the availability of police officers to provide public safety. Stinchcombe in 1991 probably had the biggest impact on policing costs and investigative time. I'm not sure if the math will stand up to scrutiny, but I think you'll get the impression that we see the impact of Stinchcombe. We used to have an 80-20 rule. Spend 80% of your time investigating crime, 20% preparing for court. Since Stinchcombe, those numbers have reversed. We spend approximately 20% of the case time investigating, 80% preparing for disclosure and preparing for court. Feeney warrants in 1997 introduced the concept of a warrant requiring police officers to apply and obtain a warrant authorizing entry to a specific residence, even if there was an arrest warrant in existence. When the Supreme Court rendered that decision, there was no legal basis to obtain that warrant. However, it has been remedied since. Okay. These decisions have had a significant value for the administration of justice, and I'm not detracting from the value. And they do provide individual protections that didn't exist previously, but they've had a huge impact collectively on police capacity. 2 legislative changes I'll touch on very briefly: conditional sentences, which is really a prison sentence that's reduced to house arrest with conditions. This has converted the police to become sentencing monitors, again, taking us off the street from investigating crime. There's also a significant decrease in support structures for mental illness, which not unusual to see 2 police officers tied up for 6 to 8 hours apprehending persons with mental health problems and then staying with them awaiting an admission into a mental health institution. Technological changes, this is my last point, technological changes. The deregulation of the communications industry has made lawful intercepts either very expensive or in some cases impossible. There are intercept-free zones of technology in Canada, and while there is new legislation pending that will require service providers to provide intercept-capable technologies that currently don't exist, but it does hinder our ability to conduct effective investigations, particularly organized crime. These are but a few examples of the complexities in the criminal justice system that impacts on the police, and we perhaps may have created a legal system instead of a justice system. But I believe the solution is in all participants in the criminal justice system working together to collaborate on a broad-based system of reforms. And with the right will and a clear vision, this can be accomplished without compromising the independence of each of the participants.
Thank you, Ian, very much. I sense that it's possible that you might have said certain things that Duncan might wish to respond to from a slightly different perspective.
You'd be right, Bruce. But first, I'm going to address the 4 questions that we were asked to address. The first one, should the public trust the criminal justice system? Now, to properly address this question, you really need to ask other questions. First, what do you mean by trust? And trusted to do what? Trusted to convict all who are charged? Trusted to lock up for long stretches all who are convicted? First of all, trust should mean, I suggest, a firm belief in reliability, honesty, and veracity of a person or thing. And I think our criminal justice system easily fits that. However, as a French philosopher, mathematician, and physicist said some time ago, to doubt everything or to believe everything are 2 equally convenient solutions. Both dispense with the necessity of reflection. And I don't think that we should simply accept this and not reflect on what our system is about. We should always want to see the criminal justice system, from investigation, that Assistant Commissioner Atkins speaks of, to the end of the trial process, demonstrate that it is reliable, that it seeks truth in a fundamentally fair way, that it operates the same or at least tries to regardless of race, creed, religion, or socioeconomic status, that it acquits the innocent, convicts the guilty, and imposes a sentence that is fair and balanced response to the moral blameworthiness of the offender and the harm done. The second question, are there compelling reasons not to trust the system? Well, there are, in fact, compelling reasons not to accept at face value that the criminal justice system has always worked properly. Bruce has already mentioned some of those names that are familiar to most of us that are study and participate in the criminal justice system. Marshall, Moran, Milgard, Sofino, Parsons, and now likely Truscott. Any human endeavor will not be perfect. However, if the errors that led to those travesties of justice are systemic, they should be identified and steps taken to correct them. And they have. Each one of those commissions of inquiry have led to significant changes in our system. The failure to disclose, I know this is going to cause some work for you, Inspector Atkins, but the failure to disclose was a major factor in the wrongful conviction of Donald Marshall Jr. Tunnel vision by investigators in Moran and in Parsons. Faulty forensic evidence in Moran and in other cases. Evidence that well-intentioned, honest people put forward, I'm sure, all in the belief that they had the right man or woman, as the case may be. It turned out to be seriously flawed. One of the most difficult things that our system has to deal with is eyewitness testimony. We have made many strides in the field of psychology about how people view things, how they remember things. In November 2006, I had the pleasure of hearing Jennifer Canino, whose name many of you probably don't recognize. She was a student at 22 years of age in the United States when she was brutally raped. And she took care to note the features of the person raping her, knowing that later she would be required to identify this person and bring this person to justice. They caught an accused individual in the area. She positively identified him. He was convicted. A new trial was ordered, convicted again. 11 years later, still insisting he was innocent, DNA cleared him, and that same DNA convicted another man who actually committed that offense. We would be naive not to think that other less glamorous cases arrive at an incorrect conclusion. It doesn't mean that we need a new system. It means that the people that work in the system, the crowns, the police, the judges, and defense lawyers must be vigilant about their proper roles in the system and have the courage to fulfill those roles. The third question is, are the public satisfied with the way the system is dealing with criminal offenders? That's the question that was asked. First of all, it is, with greatest respect to the author of that question, the wrong question. Satisfied with how the system is dealing with people that are suspects of and perhaps eventually charged with criminal offenses would be a better way of phrasing it. To speak of criminal offenders is to perpetuate and encourage the fact that the public have an ingrained presumption of guilt. It's easy to understand why. We pick up the newspapers. We see someone is charged. The police charge them. The police are our friends. They protect us. We believe them. Yet when you go into a jury trial and you get up and you say to the jurors about this presumption of guilt, that how many of you walked in this room and said to yourself, gosh, is that what a murderer looks like? Or, he doesn't look like a rapist. There's the guy who did it. And they smile because they know that's what they thought looking at this person. A sense of security, the justice provides for an adequate level of public protection. But protection from what? From crime? From the police or other government investigative agencies overstepping their legitimate investigative powers? I'll assume the question was about protection from crime. Sadly, I agree with Bruce and with Inspector Atkins, Commissioner Atkins, there is a sense of inadequacy. I say sadly because it comes mostly from a misguided impression about what the system is actually designed to do. Where does the public get that from? At least to some extent, the media. Assistant Commissioner Atkins is dead on about crime stories. The shocking ones, they sell the best, and the system that can be said to have failed, or the sentence absurdly low, how can the public not get that sense of inadequacy? Perhaps the worst are the ranting editorials hardly a week goes by without decrying the failure of the criminal justice system to reduce or eradicate crime. The difficulty with that was, and I had an editorial from last week, but this was even better today, because it was in the Chronicle Herald, on the front page of the second section. It's a story from Falmouth. Lenient sentences and pampering of criminals are part of Nova Scotia's crime problem, a task force heard Wednesday night. A total of 10 people turned out, but nonetheless, this is what they said. But those who were there and spoke all felt the justice system is coddling criminals, leading to more crime, repeat offenses, and lack of fear and respect of the law. They then described an offense that was a vicious robbery with someone with 30 previous convictions and got a 3-month conditional sentence. I'd be outraged too when I'm a defense lawyer. I just, when I love it when clients come to me and say, I want to get the same sentence that guy in the Valley got. I said, I don't think that's available. But this is even better, because it goes on to say, those in attendance had praise for the work of the police, but not for the judges. I think the RCMP are doing a good job capturing people, but then this is a quote, but then you get to court and the judge lets them off, one woman said. I have zero respect for the judicial system. Well, I think she has zero respect because she doesn't understand what the system is about. And one of the difficulties is politicians are also to blame because there are many votes to be had by being hard on crime. It lends a false legitimacy to the public's perception about the system, and justice is somehow not being done. To the extent that the public view the system that it's able to reduce crime by catching, convicting, and punishing offenders, they've been misled. But that's what the public believe. Just listen to those quotes. They think if only we caught more people, convicted them, sentenced them to longer and harsher terms, our problems would be over. This presupposes that the principle of deterrence actually works, and that people who may be inclined to commit crimes sit down and consider the consequences of their acts. Study after study in Canada and internationally have confirmed that general and even specific deterrents do not work. There's no empirical evidence to support that the longer you sentence people to jail, that it has any impact on reducing or leveling crime. And I think Commissioner Atkins the other day said, in fact, violent crime is static and has been at the same level for decades?
The last 5 to 6 years.
Yeah. The countries with the highest incarceration, that's what you said the other day, the countries with the highest incarceration rates have the highest violent crime rates. Higher sentences do not impact on crime rates. Most dangerous criminals do not fit the model of a rational thinker. Sexual offenders give in to their urges. Violent offenders strike out in anger. Furthermore, a lot of crimes are situational. The most sensational murders are in fact domestic, caused by jealousy, rage, vindictiveness. If the government truly wants to reduce crime, it cannot be eradicated, then address the causes of crime. And I think Assistant Commissioner Atkins spoke about that, to the extent they can be. Socioeconomic, mental illness, disorders, substance abuse. Don't build more jails and enact harsher, more totalitarian laws, but commit the resources to reducing crime where it can really be effective. And educate the public about what you're doing. Don't mislead them that if we get tougher on crime, somehow that's going to reduce crime rates. Those are my answers to the 4 questions. I'll have more to say about his comments later.
Thank you, Duncan. Now the view from the bench.
Okay, we'll move to center ice now. The principles in our criminal justice system, it should come as no surprise, are humans. Victims, witnesses, investigators, lawyers, judges, and jurors. Humans make mistakes. No system, the criminal justice system among them, in which the main players are human, will ever be perfect. For that matter, it's debatable whether reasonable people could agree on what constitutes perfection. It's debatable whether anyone would recognize protection if they saw it. And it's debatable whether anyone in any system of justice is capable of perfection. While not perfect, what we do have is a criminal justice system that is, I suggest, at once rational, inclusive, transparent, and responsive. It is a system regarded with envy by developing and developed countries alike, all over the world. Our criminal justice system rejects arbitrariness. Our definitions of crime, the procedure that we follow at trial, and the rules of evidence that we apply in deciding whether certain evidence will be considered or should be considered in reaching a verdict must all accord with the principles of fundamental justice. Every person accused of crime, no matter his or her station in life, or the enormity or seeming triviality of his or her alleged offense, enters our courtroom clothed with the presumption of innocence and entitled to and guaranteed a fair hearing by an independent and impartial tribunal. More often than not, the manner of trial, whether by a judge sitting alone or a judge and jury, is at least in part of the accused's own choosing. Our criminal justice system promotes and tries to ensure rational decision-making by informed decision-makers on the basis of reliable evidence. To ensure fairness for all and to guard against the prospect of miscarriages of justice, whether by wrongful conviction or mistaken acquittal, our system of criminal justice is adorned by an unyielding series of checks and balances. We do not permit arrests to be made on hunches, on suspicions, even 1,000 suspicions, nor based on caprice or on whim. Rather, only upon a reasonably grounded belief of the commission of crime. We insist that the evidence gathered to disclose the circumstances of an alleged offense comply with the standards set by our supreme law, the Constitution of our country. We require those who allege a crime to prove it, rather than, as in some places, the person who is alleged to have committed it being required to demonstrate the negative, that he or she did not commit it. We demand that proof be clear and convincing, proof beyond a reasonable doubt. Probable guilt is not good enough in this country. In some cases, a person accused of crime will have a preliminary inquiry where a judge will decide whether the prosecutor's evidence is sufficient to justify putting the accused on trial. At trial, where sometimes the evidence differs, as those of us who are prosecutors know only too well, differs from that given at the preliminary inquiry, the judge exercises a similar supervisory authority in determining whether the case will be left to the trier of fact to decide. And we insist that each person charged know the case that he or she has to meet by requiring the prosecutor to disclose any and all relevant material in the possession of the state to the accused in advance of the proceedings or immediately as it becomes known. Another hallmark of our system of criminal justice is its transparency. Open courts, public display, no closed doors, at least in the overwhelming majority of cases. Decisions require reasons, a conspicuous display of why it is that we decided as we did. Everything we do is on display for the public, who are more than welcome to drop in and observe as they see fit. Every word I speak in a case is taken down for review by not one, but by 2 appellate courts. In the overwhelming majority of criminal cases heard across the country, the person who decides is a judge who, as I have said, is bound to give reasons so that anyone who cares to know will understand why it is that the case was decided as it was. But the exclusivity of judges as deciders gives way in the most serious cases we try. Murders, the intentional killing of one citizen by another. There are very few murder cases in this country tried by judges sitting alone. It is possible to do so with the agreement of the Attorney General and the accused. But by far and away, most are tried by juries. And the judicial role is to make jurors active participants in the trial and to educate them to make their decision, not to tell them what decision to make. We have created informed decision makers. Regrettably, some of the criticism is not nearly so well informed. Thank you.
Thank you, David. Perhaps it might be useful to see whether some of the views in the center here are centered or not so centered, in the sense that it seemed to me, Duncan, that your concern about tunnel vision may not fit with Ian's concerns about the time that is spent on investigation and so on. Is there ground to explore there?
Well, I think that, yes, sure. If you want me to respond to Assistant Commissioner Atkins' comments, first of all, I don't think he would accept tunnel vision from his investigators. I think that what he was perhaps lamenting about was that there may be restrictions put on policing agencies whereby they either don't investigate or they don't arrest. Once they've done their investigation and they arrest, then it falls to the Crown, who we haven't really talked a whole lot about tonight, and we perhaps should, because they play Crown attorneys play such a vital role in the administration of justice and how they exercise their discretion. And you did refer to that, Bruce, but it is important. Perhaps we'll touch on that later. To the extent that no investigations are undertaken, surely that's not the fault of the system in any way. It can be more a resource problem. They don't have the necessary resources, the number of police officers they need, the equipment they need to pursue things. I was intrigued initially by his comments that he agreed that sentences weren't too lenient. And I just had to kind of clear my ear there for a moment because I wasn't sure my hearing was right. But then he said that, then he said what a lot of people, public, may think, that, well, listen, if someone gets 12 years, I want them to serve those 12 years. What's this parole stuff? And I think that in fairness to that system, is that it costs a huge amount to lock someone up in jail. It's, I don't know, it used to be $50,000, it's probably $60,000 or $70,000 a year now, whereby if they're out on parole or even a conditional sentence, the costs drop down to $6,000, $7,000, $8,000 a year to supervise them. I agree with Assistant Commissioner Atkins that the police should not be doing sentence monitoring. That should not fall to their shoulders. It should fall to correctional services within the province and not be a burden on their resources. But the whole notion that parole is somehow not a good idea, I expect the public hates it because they think that too often and too early and the wrong people get out. But I think there's a misconception, if you really look at the statistics, about how many parolees actually commit offenses on parole. And parole doesn't shorten a sentence. So they're out on day parole doesn't mean they can do whatever they want to and go wherever they want to do. They're still serving a sentence. and they are under control and should be under control of a parole officer, they still have the stigma of that sentence that was imposed on them, a 12-year. Say, what did you get? Oh, I got probation, versus, oh, I got 5 years in the pen. I mean, there's a stigma attached with being sent to the penitentiary, and that person will always have to bear with that. Surely the system, if they are going to reintegrate that person into the community with the highest chances of success, and there's no guarantees it's going to work, but it's a whole lot better than simply after 5 years open the door and say, we'll see you later, with no support system, no network out there, where to go, how to get a job, where to get to the schooling that you might need. So I don't think that the parole system properly understood is the issue. I'll be brief because I don't have a lot of time. The things that Assistant Commissioner Atkins referred to, Hunter, Terrence, Garofoli, making full and frank disclosure, and Stinchcombe, these are not technicalities. These are part of our rule of law. You can reduce anything. I call it a technicality and reduce it down to whatever you want. Technicalities I suggest to you, are in the eyes of the beholder. The public don't object to technicalities. They object to technicalities when they're being used by people who they believe to be criminals. If they were the ones, or their family were the ones that had the bullseye painted on them, then they wouldn't be so quick to say, oh, well, that we don't need that. And the things that Justice Watt referred to, the rule of law, the requirement for full and frank disclosure, and proper police background to actions, are important parts of our system. And Canadians do expect that these values, long-standing community values, now enshrined in our Constitution, should be upheld and will be upheld by those in the system. Those would be my comments.
Right of rebuttal.
Yes, absolutely, please. Because thanks, Duncan, for raising those points, because I previously thought we agreed so much that I might lose my job if I actually agreed with defense counsel in entirety. But I do agree on a lot of your points, but there was a couple that you made in rebuttal that I have to take issue with. I agree with you that Hunter and Garofoli represent principles that ought not to be sacrificed for summary execution. That wasn't my point. My point was that these impact upon police capacity to investigate crime, reflecting in the public's perception that the police, who are a full partner or a full part of the criminal justice system, can't do what the public expects them to do. That either the public expectations have to be modified, or, and this is not a plea for police resources, or that there has to be a change in how policing is done. I wrote down that a parole, there's a lingering stigma to parole. I suspect that your clients are probably not the ones that we deal with on a frequent flyer basis. Most of the people we deal with, it's a badge of honor as opposed to a stigma. And most of the crowns that I know fully expect any time that they're presenting sentencing submissions to find the accused criminal record in the file somewhere, because most of them are repeat offenders, which again I guess goes back to the issue of whether there was any deterrence in the original sentence to begin with. I think you mentioned the other night that most of your clients are first-time offenders, and perhaps
First-time accused.
All right, and I will give you that distinction. If I could just make two comments with respect to Mr. Justice Watts, and they're more questions than anything. With respect to the disclosure requirements of Stinchcombe and others, the public question whether there's a lingering need for a preliminary inquiry or whether that process has outlived its usefulness, and whether the principles of disclosure are being abused to the point where demands for disclosure will continue until somebody says no, at which time the claims of full answer and defense will be raised, and then we can get to the real issue of whether the mountains of paper that are being collected are of actually any use, or whether they're intended either deliberately or innocently to befuddle the prosecution of the case.
David, do you want to briefly reply? I'm thinking that we want to open this up to the general
I'll
audience.
reply very briefly, Bruce, to the Assistant Commissioner's questions. First of all, preliminary inquiries are no longer automatic. Somebody has to request one. Secondly, they can be limited, and the provincial court judges, if they see fit, can hold a pre-preliminary inquiry conference to help define the issues. It's true that one of the preliminary inquiry's functions, non-statutory function, has been a discovery function, and that's perhaps or may be less important at this stage with the degree of disclosure that is required. But that doesn't mean that the preliminary inquiry judge is to suffer it going on forever and a day. Secondly, as far as potential abuses of disclosure are concerned, it's no argument against disclosure to say that disclosure may be open to abuse. That's the simple response to that. Sure it is, I guess. A lot of things are. But do you chuck them out because they are capable of abuse? And Bruce, if I may, I have just two very brief points, one about Garofoli and the other about Stinchcombe. First of all, the complaint that we have to make full, fair, and frank disclosure is interesting, but wiretap applications are ex parte. Every ex parte applicant has to make full, fair, and frank disclosure. This was not a rule invented for wiretap affiants. Secondly, you don't get to cross-examine the affiant as of right. You need leave. And you don't get leave because it happens to be Tuesday and the judge has never granted leave on a Tuesday before. There has to be some basis for it. And thirdly, and importantly as far as Stinchcombe is concerned, and this province really ought to know this one, lack of disclosure is a well-documented cause of wrongful conviction.
Well, look, I think that we've set an interesting basis for some discussion which has a fair amount of common ground, but obviously some areas of significant difference as well.